It's Tuesday. It is April 1st. We are going to go to court today for a hearing from Friday in the Karen Read case adjacent. We have the prosecution trying to get to text messages between Karen Read and Aidan Kearney. The Commonwealth is trying to get to text messages between the two of them. He has a pending case. So it is regarding the phones taken in his pending case. His phones, text messages between him and Karen Read. The Commonwealth is saying that they want to use any text messages between the two that relate to a supposed or alleged witness intimidation to show consciousness of guilt, not to prosecute. We know that a grand jury was impaneled and did not indict on that, but to show, look, if she's trying to get witnesses to not come to court or to not say this or that, if that even exists, then they're trying to get it in to argue she knows that she's guilty and she's doing this because she knows she's guilty. So that's where they're trying to get to. So we saw that hearing where you had the Commonwealth arguing to a different judge that they were entitled to all of this, that the other prosecutor has it under that Rule 17. We've also now seen Aidan Kearney, Turtle Boy, asking for a protective order if those are disclosed, which is appropriate if you're disclosing that type of information. It would be literally for the prosecutor, for the defense on the other side, and that's it. That's not stuff that should be in motions. And I don't think it's much of a stretch to ask for because we've seen protective orders for Proctor's text messages and such. I don't see an issue having a protective order for Turtle Boy's texts that are related to a separate and different case if they're going to be used for that narrow aspect of consciousness of guilt. So this came back on calendar because it seems that some clarification is needed. So between that judge and Brennan, we are going to go to court and take a look at what they have to say.
The court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between defendant Read and Kearney and defendant Kearney concerning those three areas of inquiry.
The judge is like, I said what the fuck I said.
Specifically,
it was crystal clear.
Requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Read.
A and B. That's it. Turn those over. Nothing more. That's it. Those two. That's all.
Well, I will, of course, comply with Your Honor's order.
Thank you. Folks, I think we've covered that point, and I don't think I need to hear any further on this. The order is clear on its face, and
we need
I expect
not
the
tread
parties
any
to comply
further
with it. I'd like to turn now to the issue of the motion for protective order from...
The judge is like, I could not have been more clear. I said conversations between Read and Kearney. That's all. Well, it seems that the judge's crystal clear order that the only thing turned over from Special Prosecutor Cosgrove, who is prosecuting the case against Turtle Boy, to Attorney Brennan, that only conversations between Read and Kearney get turned over, was not specifically clear to the prosecutor Cosgrove on the Kearney case, who said, well, that loops in text messages between Attorney Yannetti and Attorney Jackson and Turtle Boy and Karen Read and all of them in Turtle Boy. And the court said, no. If this is being used for consciousness of guilt, my order said conversations between Read and Kearney, period. Not Read's attorneys and Kearney, just Read and Kearney. Now, if there are text messages where Read and Kearney are texting back and forth, then the conversation between the two of them is what would get turned over, even if other people might be on those text threads. But the court said this is a narrow ruling because it is what matches what is asked for by Special Prosecutor Brennan, who asked for conversations between the two for consciousness of guilt. Cosgrove, it seems, took an expanded interpretation of that, saying that the attorneys for Read were acting on her behalf. That isn't going to go to Read's state of mind, though, because you would have to violate attorney-client privilege to try to prove the conversations between Read and her attorneys to prove it is acting out her state of mind, and you can't get to that. It's just not going to happen. So the court said, I said what I said. And then they discussed a protective order, which we will see if that gets granted or not. It may have already been, and I have not seen it on the record yet, but we will see what happens with that protective order. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.